Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Welcome to our SpringLaw monthly webinar. My name is Lisa Stam, and presenting with me today is Evaleen.
Hello.
Sorry. If you are one of our clients, you already know that we are employment and contracts lawyers at a virtual law firm based out of Ontario. Welcome to those of you that are new with our webinars. We're delighted that you're joining us. Feel free to ask questions during the webinar. If we don't get to your question, because we try and keep these to 30 minutes, then we will reach out to you afterwards. Feel free to grab the handout of the slides and that way you have for reference afterwards. And finally, feel free to come to our website at springlaw.ca for some employer tools that we have and other resources. We have our award-winning blogs that we post every week. You can sign up for our newsletter that we send out once a month, and no spamming, everybody. And more information about our innovative programs like our subscription program and our new Boss Law Bootcamp, which are some innovative online solutions for people that are looking for either fully DIY to some other issues or some sort of hybrid. So I'm Lisa, this is Evaleen. Of course, before we start, we do need to acknowledge that we are on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, and the Haudenosaunee, and that this territory is now, and the Wendat people, sorry, and that this territory is now home to many diverse nations, Inuits and Métis people, and we are grateful to be welcome and able to present to you today on this territory. Lawyers and us need to do our disclaimer that this is all legal information, not advice. Here is a nice detailed lawyer version of our legal disclaimer that you can read. This is legal information, not advice. Okay, let's jump in. So today we are going to talk about termination. Today we are going to talk about employment contracts. And we are not going to talk much about termination provisions because we did on our last webinar on February 15th. So just go to our YouTube channel, and we posted a copy of a recording of the video there. So you can take a look, and we dove deep into just that single provision for the entire webinar. So go ahead and check it out there. We'll touch on it today because it still remains the most important thing of employment contracts. But otherwise, we're going to talk about what is an employment contract, what are the types of workers, without going into a deep analysis, but just some highlights, because that really drives the type of contract that you're going to be writing and why, what are the big picture differences between the two. We're going to talk through the top 5 ways to reduce your risks when you're writing these contracts, and then we're going to share some tips for how to make sure, you've got these beautiful contracts. How do you roll out good ones that are enforceable? All right, so let's jump into what is an employment contract. Over to you, Evaleen.
Thanks, Lisa. So we'll start with the basics here. What is an employment contract? So every Canadian employment relationship is governed by a contract. And that contract might be an express contract, so a written contract, or an implied contract, where you don't have a contract between the parties that's written, but the common law essentially determines what that contract is. Typically, an employment contract includes basics around compensation, role, hours of work, location of work, that kind of thing, as well as, like Lisa said, termination entitlements. That's a big one, which we'll talk about a little bit later. For anyone who is joining us from down south, it's just a little reminder that in Canada, we don't have any at-will terminations, which means one key aspect of an employment contract is determining what termination entitlements a person will receive when the employment relationship ends. So if we move to the next slide, we'll talk about what the benefits of a written contract are. So as we said, either you have an implied or an express contract. If you have an express or a written contract, that gives you some control over what the terms of the employment relationship are, right? So it provides certainty to the parties, that being the employee and the employer. It allows you to set clear expectations to refer back to when issues do arise. And for the employer, it can help you address some key concerns or liabilities that you have for the business. So like we said before, if you have an express contract, if you have an implied contract, the common law governs. And that means that the courts essentially determine what's going to happen when an issue arises between the two parties. And the history of, those issues that have arisen in other similar circumstances will dictate how that issue will be resolved now. On the other side of things, we also have statute, which sets out minimum entitlements that employees have, and that governs sort of the very basic least amount of entitlements that an employee may receive. And in the middle, we typically have contracts, which kind of try to limit some of those liabilities that might be higher or might provide employees with greater entitlements at common law, while also ensuring they're being given their minimum entitlements by statute. And a contract can set that out clearly, keep those expectations clear for both parties, and will be the first thing that a court looks at if an issue does arise. Over to you, Lisa, to tell us about the different types of workers.
Okay, thank you. And first of all, I want to acknowledge a few questions are coming in. And Lisa, hello to you as well. So hello, so Lisa, hello. Great name. The other two questions are around consideration. So we will be talking about that in our tips on how to roll out good contracts. So if you're replacing all your contracts for existing employees, for example, to update everything at once, we will make sure that we spend some good time on that section in this webinar, because a couple of questions have come in on that issue already. This next section I'm going to go through actually quite quickly. This idea of who is an employee versus an independent contractor, so that we can get to the risks and the direction and the tips sections quickly. So we want to just identify the big differences between employee and contractors, because this leads to a lot of confusion. Often we'll have clients come to us and ask for a contractor agreement, but what they're really asking for is either a fixed term contract for an employee, or maybe a business to business vendor contract. So understanding what is the sort of the legal box that we put this contract in will drive what kind of contract and what terms are relevant. So in the world of employment law, you have two buckets, and that's pretty much it. You have employees and you have independent contractors. Now your employees can be a whole bunch of different versions within that bucket, and sometimes it can be a fixed term employee for a year, for example. And often people will think those are contractors because they're here just on a one-year contract, but they are probably an employee. So to keep it all nice and confusing, watch out when you're using the word contractor that it's actually for people who are an actual independent contractor, not an employee. And colloquially, we do use these terms differently. So a contractor really is an independent contractor, not a fixed-term contract employee. And again, an employee can be on a contract for a fixed time and still be an employee. So today we only want to identify the basic contract differences and not dive into the test, the legal test around whether or not they're an employee or a contractor. That's a whole other webinar. But if you are looking to determine whether or not your workers are either an employee or a contractor, we've built out a form internally that integrates with one of our AI tools for determining the status. So feel free to reach out to us and we can give you a hand with that. So what makes something an independent contractor, or what are they? No, I'm not going to talk about that. What are the main terms that you should include in a contract if you have decided that they are an independent contractor? First of all, they get no benefits and no protection under the Employment Standards Act. Think of it more as a business-to-business type of relationship where they are not the vulnerable party, so they do not need the protections of the Employment Standards Act. So that is a really big starting point, and often it's that issue that drives the fight down the road when a contractor who's been your independent contractor for 10 years and gets the contract gets terminated, they now remember all the overtime they did, the CPP you didn't apply or that you didn't remit on their behalf, all these legal protections that an employee has that they can't apply for EI after, for example. They don't get any sort of paid leaves as part of your employment package that you might otherwise have. So all of the rights that a contractor or that an employee would enjoy, an independent contractor does not get. And so the contracts really need to reflect that. They need to be invoicing your business, making their own tax remittances to the government, like income tax and HST. For sure, get their HST number, please. That will solve so much. There's no ambiguity about whether or not they should have remitted HST. They can provide services to multiple clients because they are like a business in most cases. They also tend to provide their own tools and equipment. They can design their own working arrangements, hire their own workers, control the way in which they provide services. All of these are very different than the kinds of sections you would put in an employment agreement. So the central question really is the person performing services as a person in business on their own account, or are they your employee? And I know that sounds like it should be super obvious, but it actually isn't always super obvious. The big standard terms to include in your employee contracts are things like wages, payroll deductions, that the employer will remit taxes. You're paying a salary or a wage instead of a fee. Try and use the word fee for your contractors to try and distinguish. The employee typically provides all the tools and equipment, like in computers, etc. The employee is constrained around who they can work for, whether they can compete with others, whether these duties of loyalty that arise either by contract or common law, all restrict the things that an employee can do while working for you, which is different than a contractor, which is really more like a free agent. So what's the big deal? Again, contractors have no protections to all these legal rights, and our law is very protective of employees. Any ambiguity is always construed in favor of the drafter. That's a legal concept for centuries. And it's applied in the employment contracts that if there's any ambiguity, tie goes to the employee every time. And so the courts really take a look at it. Whereas an independent contractor, the courts will really defer to the contract because these are equal parties. There's no vulnerability there. So they will really scrutinize and defer to an independent contractor agreement much more than the amount of times they're throwing out employment agreements right now. And then, of course, you have all the tax and CRA potential risks. Okay, let me go through the 5 ways to reduce risks of rolling out your contracts. So now that you've got your contracts, they can be a dozen pages with a billion sections, but how do we zero in and really what are the highest priorities for you to take a look at in your employment contracts? And then right after this, Evaleen's going to talk about how to roll out the contracts in an enforceable way. So your number one risk really, and the number one priority of every contract, your number one liability always is the termination clause. And that's what's giving everyone the most headaches right now. Again, feel free to see our webinar from last month. Emily and I talked about it and went into detail. If you have no contract, the courts decide what is reasonable. So it's worthwhile for you to get this contract in place so that you don't have the courts deciding. And they will decide anywhere between a few weeks and 24 months is the right amount of notice that you should have given this employee that you've just fired. And what the court will also say is that you should be making this employee whole throughout the entire notice period. So any benefits, any salary, any bonus, all that stuff that they would have otherwise earned is what you need to pay during the entire notice period. And so getting all of that wrong is the most expensive part of litigation and what the most litigation is about. So this, we can't overestimate how important this is. And if you're looking to get your at least your termination provision updated, I do think that's critical. You will need to give the employee something in exchange called consideration, which we will talk to. If you're doing it to if you're rolling it out to your existing employees, Evaleen will talk about how to do that. Restrictive covenants is this big bucket of things that an employer can do to restrict a former employee's ability to do things after employment. So this really speaks to post-employment behavior, and it really is around confidential information, non-solicitation clauses, and non-compete clauses. So non-solicitation is really about restricting an employee's conduct around taking either your employees with them, a group or an individual, or any customer or clients. So that non-solicitation piece is really a key provision, mostly for your employees that have direct access to key clients, or where there is a real risk of them taking a group out if they're a leader of a group, or taking clients, soliciting and taking clients with you. It is much easier to enforce a non-solicit provision because it really is a direct interference with your job. What is new over the last year or two is that our Ontario Employment Standards Act now rolled out in October of 2021 that you can't have non-compete provisions in your contract. There are some exceptions if they're a C-suite or it's a sale of business. There's a couple of exceptions for very specific, tiny number of people in your organization, but otherwise you cannot have a non-compete, and that's because of this public interest of not interfering with an individual's ability to earn a livelihood. So that, get rid of your non-competes, make sure your non-solicits are nice and strong, but don't try and sneak non-compete stuff into your non-solicit, because as soon as the court smells that, then everything's at jeopardy, in jeopardy. Basically, protect your business and don't try and restrict employees. If you think of it that way, how do you protect your business without trying to restrict an employee's ability to earn a livelihood after? That will be the legal analysis the court will engage in. Concept number 3 is work ownership and confidentiality. If you have a lot of secret sauce IP in your organization, get your IP stuff vetted by a proper IP lawyer, and be very specific about what you need to protect. By default, your employees, what they do in the regular course of employment, the employer owns. They own that work product. For contractors, the default law is the opposite. So by default, they own the stuff they do, and they are just providing a service to you. So that is something that you really want covered carefully in your contracts, and another big reason why contractors, independent contractors, and employees are treated so differently. Fourth concept is company data and property. Identifying, what is a company thing versus a personal property, particularly on termination. This is increasingly important in the world of remote work at home. So really setting out, certainly the equipment, but also really setting out clear data protection requirements. And that is also just a whole big webinar unto itself. But in terms of liability, the data protection is a really big one. And the final big picture concept to just make sure you have prioritized when you're rolling out contracts is specify what governing documents apply to a particular term. And this is particularly if you have more senior level employees that get equity or some sort of variable comp. Be crystal clear what document applies to that term, particularly on termination. And this is a giant part of employment law litigation because there's money to fight about, right? There's equity and these are the larger executive comp type provisions where as soon as there's ambiguity about what happens on termination, we all go to court because it's worth the money to fight over. So if you want to really prioritize in on this will save you tons of time down the road. Okay, now that your contracts are beautiful and amazing, you have all the right clauses, how do you roll them out? Over to you, Evaleen.
Thanks, Lisa. So these next tips are some key tips for creating enforceable contracts, and This is always a challenging exercise, but these tips will help you cover off some of the common reasons that courts will find that a contract is not enforceable. So tip number 1 is you need to provide fresh consideration to make your employment contracts enforceable. That means that you need to provide the employee with something new that they weren't receiving prior to signing on to the contract. When you hire a new employee, that's a pretty simple exercise because the employee wasn't receiving anything from the company before they were hired on. So you're providing them probably with a salary and potentially a host of other benefits that they weren't receiving before. That's fresh consideration so that when they sign the contract, that requirement is covered off. For existing employees, when you're trying to roll out new contracts, which you might be doing because you're promoting somebody or you're tightening up your termination provisions, as we've talked about being important, you need to provide something new that they weren't receiving before. So that can be really anything new. It should be something somewhat significant. So it could be a one-time bonus, it could be a salary increase, and it could be coming at the same time as you're already promoting somebody and providing them with a salary increase then. Or it could be, stock options. It could really be any number of things. And to answer the question that came in earlier, you don't have to provide every employee with the same consideration. It can vary from employee to employee depending on their role with the company, etc. Legally, it simply needs to be something new and a benefit that they weren't receiving before they signed the contract. So tip number 2. Have employees sign employment contracts before their first day of work. So this is key. Once an employee starts in a new job with the new company or in a new role with the company that they were working with already, they're already providing the services and receiving the benefits that they will be receiving in exchange for signing their contract, right? So you need to be sure, related to tip number 1, you need to be sure that the contract is signed before that exchange of services and benefits happens. And this can be a real issue for employees. Sometimes it takes employees time to sign a contract. Employers want the employee to start right away. But it is a really significant concern that you should be aware of if you are on a tight timeline, because as soon as an employee starts in the position, you're going to need to offer them something in addition to what they're already starting to receive in exchange for their work and in exchange for an enforceable contract. So always sign the contract before starting the work.
And having a calendar day in there is so much more convenient. If you have them sign off at 8:30 and they're going to start at 9 a.m., it's still messy evidence. So it's so much cleaner and better. Just have them sign off on Sunday evening, if you're down to the wire, because then the evidence just lays out much nicer as a different calendar day.
Thanks, Lisa. So tip number 3, don't deliberately or inadvertently contract out of any minimum standards. So as we mentioned at the beginning of the presentation, each employment jurisdiction has employment standards legislation, which sets out the minimum standards that will apply to most employment relationships. And that's what our legislature has decided is the minimum entitlements for employees in that jurisdiction. So in Ontario, we follow the Employment Standards Act. And while employers and employees are free to create contracts and enter into contracts with each other, and as we're talking about now, it's a good idea to do, you can't contract out of those minimum standards. So that means, those minimum standards generally cover things like vacation and overtime entitlements and minimum wage. And so you can't enter into a contract with an employee which has them agree to receive less than what is provided for in that statute. This sounds simple, but it is another area that employers sometimes get into trouble with because they have accidentally contracted out of minimum standards by not including clear or careful wording around different minimum entitlements. And as Lisa also said earlier in the presentation, if there's any ambiguity around a term in an employment contract, it will be interpreted in favor of the employee. So typically that means that where that ambiguity exists, that term of the contract will be invalid. And this has become the big issue over the past couple of years with respect to termination provisions. So again, take a look at our webinar from last month to find out more about what that means. But definitely be careful about those minimum standards, and if you have questions, check with a lawyer. Tip number 4, contain your greatest liability with an enforceable termination provision. I won't talk about this too much more because I think we've drilled that into you already, but termination provisions, really important. Make sure that they're in there and make sure that they're enforceable. Tip number 5, regularly audit and refresh your templates. So this is a big one because employment law changes regularly. Even over the course of the past year, we've updated our own templates a couple of times as a result of changes to case law that change the way that the court interprets specific words or language in specific terms in the contract. So that's why it's important to regularly check in on your templates and the contracts that you're using to make sure that they remain legal and enforceable, and integrate customized legal advice when you have complex or tricky terms. So templates are great. We have our own templates that we provide to clients, but sometimes, often it's worth it to get the extra set of eyes from a lawyer to just check to make sure any, customized terms are up to par. There's lots of technicalities in contracts, as we've talked about, so it's worth it to get that extra set of eyes. Okay, so we've talked about a lot today. Key takeaways around employment agreements are: 1, proactive investments in contracts save time and cost on exits. 2, know the exact type of role the contract is for, so whether that's independent contractor or an employee. And 3, how you roll out the contract is as important as what is in the contracts, because if you have a beautifully drafted contract that isn't rolled out properly, it is likely to be unenforceable. Mm-hmm. So I'll pass it back to Lisa.
Sorry, Evaleen, you're good?
Yeah, go ahead.
Okay. So as you can see, contracts aren't just the funnest part of HR law, but they are also your key document to reduce your liability. So if you're looking for a more cost-effective DIY approach, we do have a number of tools that you can access on our website store 24/7. And they're each a different scale and scope depending on what you're looking for. For some people, it's handy to grab the template, just cross-reference with their own and update the terms. For others, they may want to just start from scratch with one of our templates as the base and then integrate their own unique workplace culture type terms into the template. Either way, we're here for that set of legal eyes afterwards to either review your final version or, just trying to make the whole process more smooth and cost-effective for businesses where starting from scratch with a great big bespoke contract isn't always the best use of anyone's time. So here's just some different options for you. We have a very well attended webinar today and a ton of questions that have come in. So what I propose, if this is okay with you also, Evaleen, is that we stay on for another 5 to 10 minutes and just try and answer these questions. But if people need to hop off because people have schedules, for sure hop off. And then if you want to pop into our YouTube channel later, this will be posted on on that so that you can hear what some of the questions were. But I want to make sure that we answer some of these questions, and there's a theme amongst them, so I think it'll be good for us to address that. Thank you, Jess, for throwing into the chat the link to that termination webinar that we were talking about that we did last month. So why don't we jump into some of these questions? Thank you to anyone who is hopping off for joining us. Please join us next month if you can, same time, same channel, and we're going to talk about, Evaleen is going to talk about complex employee statuses with Tiffany, frustration of contract, job abandonment, long-term accommodations, leaves. For some reason we thought it was a good idea to put all the hard stuff in one webinar, so if you are hopping off, please join us next month. Okay, let's answer some of these questions for those that are staying on. So consideration really seems to be the biggest one. How do you update a contract and then roll it out so that it remains enforceable? So one question here was, does their hire date change? And so what do you do in this new contract that you're rolling out for an employee? I love putting right in there, we will honor your original hire date, or your original hire date was, January 13, 1997. All terms in this, new contract that turn on length of service will be honored. Just stick it in there so that there's no ambiguity later. Again, any ambiguity gets construed against employers, so you're better off to just put it in there, not try and sneak in that maybe we can cut off 10 years of service, because the courts will notice, and so will that employee's lawyer. So just stick it in there and honor the seniority date. And so now you've got this new termination provision that's hopefully enforceable, and so it'll be still tied to the original termination date. There isn't a way to just stop paying people termination pay, but having clarity will help really lower the overall exposure. Evaleen, you already answered this, I think, whether or not you have to give the same consideration, or you can vary per, depending on the role and the compensation level. Not a peppercorn, right? That was, okay. Correct, non-compete clauses are now illegal. But for ones that are drafted prior to October 25, 2021, Evaleen, what do you think?
So those are okay, but if you're going to be updating your contracts, for example, to address potential termination liabilities or whatever, and you roll out a new contract, you're going to want to just check in on that non-compete clause. If you have employees who are on non-compete agreements and they entered into it prior to October of 2021, those, according to the new Ontario legislation, are, assuming that non-compete clause is enforceable to begin with, that may continue to exist in the agreement.
If your workplace is outside of Ontario, then this October 2021 date doesn't matter to you at all. So if your employees are in Saskatchewan or some other province, it won't matter. But what will matter is that the common law, so court judge-made law, still really doesn't love non-compete. So it's still very hard for an employer to enforce a non-compete if it's preventing the person from working. So non-competes remain complicated, but in Ontario, we now also have our legislation that speaks to it. Is having a standalone or a standalone confidentiality policy and non-solicitation policy upon hire, is it just as effective as having it in the employment agreement? I really prefer having everything in one place. It's so much easier when you are turning to this in 5 years, 10 years about what their, or 1 year, what their terms of their agreement are. Having it all in one place is so much better. What we do see, and what we do often, or employees ask for it, is to sort of elevate the importance of something like our confidentiality or our IP work product or our data security, to have it as an appendix to the contract so that you can have an additional signature on that. That's fine. Legally, it actually doesn't really matter, and you are drawing more attention to it, so it does speak to the employer's priority to this, and that's an argument that you can raise down the road. But if you just had a really good confidentiality provision in the middle of your contract and the employee properly signed off and consideration and all the other things were in place, then you're going to be fine also. So from from an HR administrative point of view, having fewer documents floating around are always better. But what I would say is don't stick it in a policy somewhere and then incorporate your policy by reference into your employment agreement. There's like a degree of separation there that doesn't make it as powerful as sticking it right in your contract, especially something around non-solicit and non-competes. Confidentiality. Hopefully you don't have much of a non-compete in there anymore. Okay. How do we address this scenario when a manager jumps the gun and has the employee start before signing their employment agreement? And if we had even a dime for every time this happens, and probably all of HR can say the same thing, we would all be rich and not even working anymore. This is such a problem. And it's like some rogue manager that's like on top of things and probably also using an old template, by the way. So it's like a double whammy. It is what it is. Then you need to just give them some extra consideration if you want it enforceable. Like, don't go to all this work and then not give them consideration. Do you have any thoughts on that as well, Evaleen?
No, it's one of those unfortunate situations where you just have to kind of bite the bullet and add something to sweeten the deal to get them to sign the agreement.
Yeah, it happens a lot. We understand it happens a lot. Yeah. Do we specify in the contract that the added perk is in consideration for another change of contract? And that, yes, that's in the same way you should put in original start date so that we're clear on length of service. I also like right at the beginning, as consideration for entering into this contract, we are offering X. Just put it right in there. And not even in a cover email, because the cover email is going to get lost in 5 years when we're all fighting about whether or not this person got sufficient consideration. So putting it right there in the contract is just less details floating around.
You don't need to specify what the changes in the contract are that you're providing that consideration for at the top. Maybe that was obvious already, but like Lisa said, you can just say in consideration for this new contract.
Yeah, good point. You don't need to list out all the changes and give them all the legal argument. Just say that you need consideration. Is there alternate wording we need to add to the agreement? Not sure what that question is. Maybe if we haven't answered it, just pop in. Evaleen, do you know what that one's referencing? No?
Not sure, no.
Sorry, it's probably relevant to the thing we were saying at the time, and it's been lost now. Can employees on fixed-term contracts receive employment-related benefits such as vacation, sick days, and group health benefits? You want to answer that, Evaleen?
Sure. Yes, employees on fixed-term contracts can receive those employment-related benefits, and if they're employees on fixed-term contracts, they're still entitled to those minimum amounts under the Employment Standards Act. So that's an important thing to just be clear on, as Lisa was talking about. If they're an independent contractor, the ESA doesn't apply to them, but if they are an employee, even on a fixed-term contract or temporary, most of the ESA does. There are some caveats like termination entitlements that are a little bit different for employees on fixed-term contracts depending on the length of term. But the other basic entitlements like vacation and sick days still apply to them. And as a company, you can always offer to provide them with employment-related benefits if you want, in addition to what's in the minimum standards.
Yeah, all subject to your insurer, by the way. But typically, clients do, especially if it's like a 1-year contract. If it's a 3-month one, then you might not want the hassle. But if it's a longer one, like a year, covering a mat leave, for example, then talk to your insurer before you make any promises there. Thoughts on whether or not to omit new employee's address on their offer? I haven't thought about that before. Half the time we don't have it, and it's just an email address. So it's not relevant. like, it's not mandatory. There's no legal reason why you have to include that on there. It's not like it's a client ID thing that lawyers have to go through for, you know, onboarding someone as a client. I think that's optional. Yeah, I don't think there's no legal reason for that one. If you recently presented a new contract to an employer with consideration and an employment law changes that changes the validity of the recent agreement, do you have to provide consideration again? That's the headache everyone's going through, right? And the case law is moving quickly, really quickly. I've been doing this for 19 years. In the last 3 years, and you throw in a pandemic, you know, to make it even more fun. And like the case law keeps moving so quickly. So yeah, this is the core of the problem, and why looking at your contracts at least once a year is important. And then being aware, you know, keeping some sort of database. If someone you know, received this version of the contract, you know, in 2021, and probably is now not enforceable because of X or Y, and then figuring out how to roll out an updated one with a bit of consideration, or let it go and just know that one's not enforceable, right? I mean, I also think if you've got someone who's 30 years with you and they're 68, they're just going to get 2 years no matter what. So I wouldn't even bother trying to go through the whole thing around giving them a very contained contract. You're really asking for trouble. So there's context. Sometimes it's really not worth the money or time and stress and opening that Pandora's box to make sure that every single one of your contracts is enforceable. Sometimes, because there's, what, a 50% chance that employees are going to resign and leave anyways. You don't even need to worry about that termination provision. So it's, you know, it's assessing your own internal risks as well. Let's do one more. We're 12 after. Evaleen, was there one here that you see that's actually, okay, here, this is a good one. In terms of not being able to have a non-compete, what if an employee wants to freelance with a competitor with the same kind of work? So the gig economy and working with other employer, or starting up your own business, for example, on the side, it definitely is all the rage now, and well promoted. There's tons of coaches online that that really promote this. And so, and in the world of remote work, it's a lot easier to do it without visibility to your employer. So this is a live issue with many of our clients right now. So what can you do? So you cannot force an employee to only do your job. Moonlighting has been around forever, so that's not an issue. They can always moonlight, but they cannot do it during your regular work hours. So they can't engage in time theft. They cannot work for a competitor that is now diverting profit. You know, they can't work. There is a conflict of interest duty there that they are not allowed to engage in while employed with you. So they can't. I mean, if it's like working at one grocery store as a teller and then they go and work down the street as a grocery store teller, that's probably not going to be a conflict. But if your employee is like head of sales in your grocery department and they go across the street and do head of sales at another place, then there's a conflict of interest. And so then you can say, no, you can't do that. And so you can always enforce a non-compete during employment. It's post-employment that's the issue.
Yeah, and remember that confidentiality and IP agreements will also help in that situation. Like, employees are not permitted to share information that they've learned through the course of their employment with you in other work with another business. Likewise, depending on the terms of an agreement they have with you about the product that they produce while they're working for you, they can't use that product when they're going and working for another company. So those are all pieces of provisions that are permitted in employment contracts that can help protect you in that situation too.
Exactly. Okay, there's still a lot of people staying on, so I'm just going to roll with another question here, and then we'll try and answer everyone's questions while we're here. So here's, speaking of roll, can we roll out updated agreements without offering a new benefit? So this just goes back to that fundamental principle that when you're rolling out an updated agreement that's now enforceable, you are taking away an employee's legal rights. If you think of it that way, you are taking away the legal right to that very generous default common law termination provision. That's usually what this is all about. So if the contract didn't exist or is not enforceable, that employee is going to get the widest, most generous amount, because the common law tends to be the widest, most generous amount. So what a court would award, anywhere between 3 to 5 weeks per year service, up to about 24 months. And that's going to be all probably way more than what you have in your contract, and it's way more than what minimum standards are. So the ESA really is just a floor. It's not any sort of ceiling. And so if you roll out an updated contract that now makes these termination provisions enforceable, and they weren't enforceable yesterday, you are now taking away that legal right to common law, which is all legit and fine and fair, because you're offering, you know, a compromise in place of what they would get. And so this is what the consideration piece is all about. You have to give something in exchange for taking away that legal right. And so, and that's why if you're taking away 2 years of a great big salary of a very long-term older worker and you want to give them just 1 day of vacation pay, that's not going to count, right? You'll have to give them something much more than that if you're taking away a larger legal right. So, the long answer is no, you cannot roll out updated contracts without offering some sort of new benefit or something of value to the person. What's the next one here? Would you recommend a policy around gig work? I mean, maybe not. I mean, if you think it's a live issue, but you're kind of, for sure. I mean, remote work and what the terms are around remote work can often start to include this. But there usually is, and certainly in our templates, there's a duty of loyalty section right at the beginning that would cover most of that you can lean on. Evaleen, are you seeing any? Did I miss any other questions, or should we wrap this up?
I think there's a few, but they're pretty specific. So I'm thinking our answer would be it depends on many contextual factors that will relate to the question. So I think maybe we can wrap up now.
Okay, we will wrap up then. Thank you everyone for this was interestingly one of our better attended webinars, and so many of you stayed on, so thank you very much. Again, join us next month at our next one around complex employee statuses. Feel free to follow up with any questions that you may have. Come join our website, follow us on social, Facebook, Twitter, LinkedIn, Instagram, TikTok, YouTube. Sign up for our monthly newsletter, and thank you very much. We will see you all next month.
Thanks, everyone.